The Firm, India's only show on corporate law, tax and audit matters.
The Companies Act 2013 is probably the most botched law I've seen in the 20 years I've covered business. And to think that it's the most important commercial law in the country. Remember that it took governments and Parliament almost a decade to rewrite the 1956 law. As a bill, it went back to the Parliamentary Committee twice, and both times the committee was headed by a veteran BJP leader. The then UPA government rushed it through before the 2014 elections. And when I say rushed it through, I mean rules were being notified till the last hour before they became effective. So far, only half the Act has been notified. So for half the provisions, companies are abiding by the 1956 law and its rules, and for the other half, the 2013 law and its rules. Now, when it came to power, the BJP decided that the Companies Act 2013 was not good enough, even though in Parliament it had supported the law. So the new government amended this half-notified Act once and then set up a committee to recommend more amendments. That committee report was released last week. It recommends over 100 changes. So 10 years in the making, last-minute haste, half-notified, once amended, and now the Companies Act may be in for a large-scale rewrite. What would that rewrite entail? Well, to discuss that, I'm joined today by Bharat Vasani, member of the Companies Law Committee and, of course, General Counsel at the Tata Group, corporate lawyer Sanjay Asher, senior partner at Crawford Bayley, and senior auditor Dolphy Dsouza, who's partner at EY. To all three of you, a warm welcome. Mr. Vasani, I'm going to start by asking you to describe what the mandate of the committee was. And the reason I ask is not because I don't know the mandate, but the committee has recommended 100 changes to the law. That's just short of a full rewrite. Why not just recommend a whole new law?
Well, I must clarify at the outset that the mandate was not to rewrite the Companies Act 2013. See, in the first year of its implementation itself, the government received a huge feedback from various chambers of commerce, directly from the industry and various stakeholders that there are a lot of pain points. And they wanted to address those pain points. They found that some of the provisions were just not workable, like sections 185, 186, to ask you for loans to directors. There was absolute prohibition. They realized that this was an overreaction to some of the corporate scandals that had happened at that time. So the very first meeting, which was chaired by Anjali Chibdukal, who later on became the finance secretary, it was very clearly told to us that we are not rewriting the Act. We are just addressing the practical difficulties which we encountered in implementation of the Act. And I think when we debate, I think that was not the objective. So very substantive or conceptual issues like treasury stock buyback or introduction of provisions for leverage buyout, nothing was discussed. We just invited comments from all the stakeholders. We received more than 2,000 comments. And our objective was only to look at the comments. None of us were individually allowed to make our own contribution.
No,
we
fair
had
enough.
to look at those 2,000 comments.
But wouldn't it be fair for me to say that these 100 changes, and I ask both of you gentlemen as well, these 100 changes effectively amount to a rewrite of the law? Would you say that?
Absolutely.
Dolphy?
Yes, absolutely. And I think we are going back to then the 1956 law. Then there was
in many
cases,
okay.
Or the substantive.
So let's do one thing. Let's get down to the fine print and we'll examine all these objections that we have and find out where we've reached at the end of this exercise. Of course, these are all only recommendations and we yet have to see how many of these are accepted by the government and in fact legislated on. But let's start with the very first issue that you, Mr. Vasani, said was posing to be an operational issue for most large companies and groups, and that had to do with loans to directors and then loans to intercorporate loans and investments. As far as loans to directors are concerned, the Companies Act disallowed loans to directors or any person that the director is interested in. Your committee has recommended that these loans be permitted to directors or any person that directors are interested in as long as shareholders have approved them in advance, correct?
Yes.
Now, there was a clear governance reason for why loans to directors had been disallowed by the Companies Act 2013. Why have you all suggested that that disallowment be done away with?
185, which put an absolute prohibition, I thought was a drafting error. You can't have a absolute prohibition that you can't give a loan to any company in which your director is interested. There was no question of getting government approval. The old section at least contemplated that if this loan is required to be given, you can go to Government of India and justify to the Ministry of Corporate Affairs that this loan is justifiable. Here there was an absolute embargo. So what we have now proposed is, if you need to look at it in the context, that in 2015 there was an amendment, short amendment bill which was passed, where this section was amended to provide that loan by a wholly owned to a wholly owned subsidiary was kosher.
Okay, I get that. So that was an
But even
operational
that was
difficulty.
not, but that was also not found to be workable. So we found that let's give it to any company in which director is interested, so long as shareholders by 3/4 majority have approved it. So we have gone back to the shareholders, corporate democracy. If shareholders are fine with it, why should government object to it?
This recommendation is reasonable and good because a lot of companies operate through their subsidiaries for multiple reasons and
And they
genuine
have
reasons.
common directors on subsidiaries?
Sometimes, yes, they do have common directors.
Often these are not subsidiaries and these are companies in which the promoters are directors or there are common directors by some other reasons. Shouldn't there be governance reasons for not allowing these?
For monitoring them, not for not allowing, because then what you're doing is you're throwing the baby with the bathwater.
I would agree with him, and I would only supplement to say, even the listing LODR, the new LODR, and the old listing agreement did mention that you had to have on material subsidiaries director of the holding company. In which event, how would you say just merely because there is a common director, I cannot give him loans?
So we've
You
left
can't
it up to
just-
shareholders.
Yes.
We've left it up to
You
shareholders.
look at the jurisdictions. We did international comparison. Which jurisdiction has banned it? And there is not a single jurisdiction which has banned it.
As
Okay,
long as
fair
it is
enough.
arm's
Yeah,
length,
absolutely.
Fair enough.
and then you are paying through the proper interest.
Okay, fine, fair. The next one where the committee has recommended a change has to do with intercorporate loans and investments. Now, one of the things that the committee has recommended that the prohibition on more than 2 layers of subsidiary companies that was in the Companies Act be done away with altogether. This again, I understand, is a case for operational ease because in many industries, for instance, in infrastructure, you might need more than 2 step-down subsidiaries,
Absolutely.
right? But there were, again, very clear reasons for why this restriction was put in.
See, there is a corresponding change being done in some section of the company, 187, which was old section, the sections dealing with beneficial ownership of shares.
Yes.
We found that we have introduced sufficient safeguards and checks and balances that there is no need for us to restrict the layers. And we found not only infrastructure companies, there are a whole host of sectors
Yeah, I just gave an illustration.
where we believe that there is no need for the Ministry of Corporate Affairs to put artificial restrictions which takes away the structuring flexibility of companies.
Okay.
It's very critical that you need to preserve structuring flexibility, and one of the core principles given to us by the PMO is of doing business. We don't want to bring in anything which will come in the way of ease of doing business. So if you see large number of suggestions which are directed at this point of time, is it obstructing legitimate business activity? If
Fair
it was so, we do it.
This particular recommendation was there in the JJ Irani committee as well, report.
That don't have restrictions on
Don't
layers.
have restriction on layers. You also had in the parliamentary standing committee, again the same recommendation was there. So, I mean, if it is coming for the 3rd time, I'm sure we are all facing problems and there is no issue from a governance or any other point of view.
Fair enough. Okay. Speaking of governance, the committee has proposed that the government circular, which says that only the interested related party cannot vote in a related party transaction, that be rescinded, and in fact the original position be restored, and that is that no related party can vote in a related party transaction, related proposition or resolution. That is a huge win back in favor of governance, Mr. Vasani.
I think this was one provision where I think there was no resistance at all. Wow. Everybody was on board, and it is also to bring it in line with SEBI. SEBI has already said that all the related parties are prevented from voting. So we realized that there are only 2 situations: unlisted closely held companies and JVs, where we may not have a situation where there is both the parties may be interested, then how do you go about?
Fair
so we are carving out for those 2 specific situations. Otherwise, we felt that if you keep the circular alive, there is a very nice way of bypassing the entire regulatory requirement. So we thought it was better that we withdraw that circular. And in fact, there are 2 other changes made in the related party provisions which are tightening the tightening of the Act. For example, there was a drafting error in the definition of holding company. 56 Act contemplated holding company can be a body corporate. 2013 Act did not contemplate holding company to be a body corporate. So technically, I can argue that Unilever and Hindustan Lever were not related parties. So if there was a very material...
Because one is a foreign company.
One is a body corporate, which is a foreign company, which was not covered by the Act.
Correct.
So we have plugged that drafting lacuna also. It's not that everything was liberalized. This very clearly says that even a foreign body corporate related party transactions provisions will get attracted now.
Okay.
On the related party transactions, I think the materiality thresholds are actually very ridiculous because the requirement is 10% of turnover or 100 crore, whichever is lower. So imagine a huge company, with an 80,000 crore turnover. Even for smaller transactions relatively from their perspective,
they have to go to shareholders.
They have to go to the minority shareholders for approval. And there is also disharmony between the legislation. So, for example, under SEBI legislation, it's only 10% of turnover without any upper limit of 100 crores, and it's of consolidated turnover. So, this disharmony between the various legislations and the lower materiality thresholds is going to be creating confusion.
We have not written it here that in all the thresholds prescribed under the Companies Act are in for a comprehensive review, and a decision was taken in this committee. We are meeting once again. All the thresholds are going to be substantially revised. So the thresholds are not.
You're just strengthening my first question. Why aren't we just writing a new law? Because I can't believe it.
You are revising most of the thresholds.
Speaking of definitional changes, because you spoke of holding companies, there is another definitional change and an important one in that, in the definition of associate and subsidiary, where you've said that the Companies Act says significant influence means control of at least 20% of total share capital in determining whether it's a subsidiary or an associate. And you've said let it not be total share capital, let it be total voting rights, which seems to make imminent sense because it does away with preference capital. But I want to ask our two guests here whether they agree with this change in definition.
Absolutely. And the thing they could have streamlined was that you have the definition in AS 18, you have it in accounting standard.
So why not have the same
Why not have the same definition everywhere? Otherwise, you have again inconsistencies.
I have a big disappointment on this because I believe that control and subsidiary, significant and influence and associate, they have to be clearly separated. So the definition right now that is being proposed is significant influences either participation in decision making or control of business decisions. Because if you control business decision, then there is no longer significant influence. It's actually controlling the company, and that's no longer your associate, it's a subsidiary. So that fundamental change has to be addressed.
So what would you have preferred that the committee recommend?
I think first the committee should have made a distinction between participative rights and protective rights. And significant influence has to be determined as participation in decision making, not as control of business decision, because then there is no difference between significant influence and control.
Okay.
For example, if you have an agreement.
There is. If you read the committee report, there is a reference to this whole debate on protective rights and participatory rights. So I'll let you answer that because I know that the committee thought through this very carefully.
This was discussed at length. We also saw that nowhere in the world, forget about India, any legislature of the world is able to define control very effectively.
Sure.
And you know, these are all fine nuances. I myself was of the view that perhaps the word in any other manner in the last part of the definition be taken away. We need not completely align the definition of control with SEBI takeover code because it's very, very exhaustive definition. The feeling was that the controls are exercised in the modern world through so many different ways that they felt that it's better that we align our definition with SEBI takeover code. And we don't need to make any change at this stage. This was debated at great length.
I want to move on then to the issue of raising of capital, where the committee has recommended several changes to the private placement process as well as material changes. I'll just bring up one because it's actually a few pages of changes. It's impossible to cover all of them in great detail. But I think one of the things you all have said is that a company can keep more than one issue of securities open at a particular given time. And then there are a whole bunch of procedural changes. If you want to just in very brief, Mr. Vasani, tell us what it is that the committee was attempting to do in many of these changes.
See, there was a, based on the representations received, there was a view that overreaction to Sahara. This was a Sahara amendment. So in overreaction to that, too many restrictions have been placed and people were finding it very difficult that you can't open a second issue till the first issue is technically completely closed.
Correct.
So the view was that we must facilitate raising of capital. The industry is going through difficult time. The national economies are going through difficult time. The world economy currently, this was discussed at length. That is what we can do that both the IPO and the private equity and the private placements we can facilitate. And one of the view was that let's try to remove some of the procedural restrictions. So we have not completely taken away all restrictions, but the procedural part, the PAS 4 form and the PAS 5 forms and the private placement offer memorandum, we felt it was too much of a burden, some requirement.
Too many filings.
Too many
I
filings of valuation report.
Yeah.
So we said let's get away with this and keep it to the bare minimum. And there was no harm if the two issues are simultaneously open, so long as your total number of subscribers do not exceed 200 in a year.
And the good part of it is that you could have multiple issues in a single year. That's the best part of it. Otherwise, there were restrictions.
Through a single approval, I think, if I understand that correctly.
Yeah, not only that, as far as NCD is concerned, we have even given a go by to that you don't need an annual review or renewal of the NCD resolution. Once your total borrowing is within the limit specified in section 180,
then you have enough flexibility.
Enough flexibility. Our objective was to bring in flexibility back on the table.
I think some of the changes are pretty good. So, for example, in the case of IPO, they've said let SEBI determine what are the disclosures required. So, right now, when we make disclosures in the prospective, it's effectively disclosures of 5 years in accordance with consistent accounting policies. And 5 years is too long, really. So, we don't have to have 5 years.
And SEBI requires 2.
SEBI 2 requires 5 years because it is linked to the Companies Act. But now the proposal is let SEBI decide. And my guess is SEBI would say, look, 5 years is too harsh. Let's allow for 3 years of disclosure in accordance with the Ind AS or whatever the standard.
May I just say that we had co-opted SEBI member of the committee, Mr. Nagpal, and the view was that SEBI is currently having a comprehensive relook at the entire IPO disclosure requirements to prune it. And the Companies Act requirement would be exactly in line with what SEBI is prescribing.
Another place where you have done that is to propose that the provisions dealing with the restrictions on forward dealings by KMPs, as well as the insider trading provision in the Companies Act 2013 be deleted, because effectively SEBI's regulations in this should be the ones that prevail, and you didn't need overlap in the Companies Act.
No, there were two fundamental problems. The 195, which dealt with insider trading, didn't say it was meant for listed company. It was applicable to unlisted public companies and private companies.
Which made it an operational issue.
Unfortunately, the law laid down in that section 195 was based on the old 1992 regulations of SEBI and not the new 2014 regulations. So the fundamental 15 regulations. So the problem was there the carve-out was ordinary course of business. Here the carve-out is legitimate corporate purpose. So we said that first of all the law is not aligned. Second thing, the unlisted companies, there is no market, there is no price discovery, there is no question of insider trading. So why are we trying to legislate something which is not applicable to unlisted companies and private companies? Keep it, as far as listed companies are concerned, SEBI said that we have a very comprehensive and tight regulations. So why do we need to legislate? So after a prolonged debate, we thought both these sections were completely unnecessary in the Companies Act.
So you're all in agreement that these two sections needed to go, and the proposal is to do away with them.
Absolutely.
Okay. Dolphy, I think this change that the committee has recommended will gladden your heart. The committee has said with regards to reporting on internal financial control that auditor reporting obligations on internal financial controls should only be in reference to financial statements and not all financial controls in a company. I think this was a wording change that the auditor fraternity had been asking for ever since the enactment of the 2013 Act. Now it's finally been sort of in black and white put down by the committee.
Right. So there are two types of control. One is the business controls and the other is the financial control. So typically business control would mean, does your product have an FSSAI stamp on it? Now that's something that really auditors don't deal with. They look at more financial statements and financial controls. But the other thing that I would like to mention here is as far as directors are concerned, they are responsible for all controls, business controls as well as financial controls. So there should be no exemption as far as directors are concerned.
And
because
there's no exemption proposed.
There is no exemption proposed. But the problem here is when the directors make an assertion that business controls and financial controls are in place, there is a huge level of work and documentation is required by the directors and the people that work for those directors to say that the business controls are in place. So there is a lot of administrative effort that the directors will have to put in because of the 2013
So you're saying
Act,
that too should have been done away with is your point here.
Absolutely.
The directors have expressed serious concerns that how can they confirm that they have laid down internal financial controls and they are operating effectively and satisfactory. So there was a very strong representation coming from the body of independent directors that they are finding it extremely difficult to certify.
So why have you ignored that? So 101 versus 100 changes would not have changed anything much.
This was the majority view.
The final point I want to bring up, and that has to do with remuneration of key managerial personnel, and the committee has recommended that wherever this remuneration exceeds limits laid down in the Act, as long as you have shareholder approval, you don't need to go to government for approval. There are other relaxations you've sought, for instance, a company that's not making profits. Again, you don't need to go back to government for approval. So essentially, you're saying if shareholders have approved, you don't need government approval.
So we have made a distinction now. Promoter director, you can do a special resolution, but professional director who has no stake in the company or his stake is less than 2% and is the domain knowledge of the industry, then ordinary resolutions. So we have also tried to address a situation like Tata Motors, where we have a problem that the special resolution is difficult to get passed sometimes.
But you did manage to pass it the second time round when you made the explanation available to your shareholders.
But it creates a lot of difficulties, and a lot of complaints have received that it is difficult because you are not allowed to vote on some of the resolutions. So the best part was that let's make it ordinary for professional directors and let us leave it to the shareholders. And we found that not a single country in the world.
But in many promoter-run companies, the professional directors are people picked by the promoters, Mr. Vasani.
But we have laid down strict
Everybody
criteria.
is not a Tata Group.
Picked by, but they need to meet the criteria laid down in the Act, and let us leave it to the shareholders. Why?
But a simple resolution will mean the promoters' vote will drive it through.
But what is the value addition done by referring the file to the government? What is the value addition done by referring the file to the ministry?
That's also a fair point, but at least there was some, well, yeah, okay.
I think it's a very welcome measure.
Last bit, this irked me a little bit, and I'm not sure if everybody here would agree. The committee has asked for companies to have a more generic object clause that they can put in, which is to engage in any lawful activity or business. Then why have an object clause at all? Because it sort of defeats the whole purpose. So before I come to you for an explanation, I'm going to get views. Do you have an objection to this?
Yeah, I have. I do not really agree with this change because let's say if I'm investing in a software company, I'm investing in software. I'm not expecting the software company to start buying and selling property.
Yes.
Right? Because otherwise I would not have invested in that.
And the moment you
company.
allow for this kind of generic object clause to be included, every company will put that into their AOA or their prospectus, right?
Absolutely.
So,
I would agree. And then you don't have any mechanism as to from software if I'm trying to do with real estate. Earlier, at least, there was a mechanism that it was not germane to your main objects or the business which you are doing. Go back to the shareholders, pass a resolution, take their approval, and then commence that
now
business.
the Companies Act 2013 says you have to even give dissenting shareholders an exit, for which SEBI has finally, after 2 years, come out with a process,
Correct.
right? So
and now, if you are saying that you have generic object clause, which to my mind is
not acceptable.
The view was that the English Companies Act world over is regarded as one of the landmark legislation in terms of balancing the requirements of corporate world and the governance requirements. If you look at section 31 of the English Companies Act, it specifically permits this kind of a generic object clause. That so long as you do something which is legal and permissible, the old concept of doctrine of ultra vires and all the thing, they find that they have lost relevance in the modern world, and Companies Act provides that in case the company changes the objects, the shareholders who do not agree with the new objects have a right to exit, and most of these objects will be there in the IPO offer document.
Put this generic objects,
IPO offer document, you will have to write the objects, and if you have taken the money from public and if you change the objects.
What if you use this generic objects clause then?
The issue is that the generic object clause, it will be reproduced in the articles of the company. The people who subscribe to the shares of the company need to know that the company has a generic object clause, so it has a flexibility to do. But I suppose, there are several other checks and balances. So the feel was that objects clause need not be one more obstacle in the way of company wanting to diversify its business.
Okay. Can I ask you the last and final question on this debate? Do you think that it's better to make all these as amendments, or should we just rewrite the 2013 Act?
I think it will take another 10 years, so better make these amendments and live the life. I think let's be more practical. If you rewrite the Companies Act again, or otherwise, section 465 repeal has still not been notified, then bring back the 56 Act. But don't rewrite the Companies Act. For 5 years, if you feel that the company industries need to do business more easily, bring back the 56 Act. I would be supporting that.
Even in 56 Act, after 56, there were amendments in 60 and 65, and the 60 and the 65 amendments were as very many as what have happened in the last 2 years or what are proposed to be made.
We just don't seem to be able to write company law very well in this country. Gentlemen, to all three of you, thank you very much for joining us, and thank you very much for watching. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.